Hello, everyone, veterans, dedicated VA employees, everybody watching. Hey, welcome back to the Veteranling YouTube channel, where we are going to talk about another VA disability topic in an educational format. Please remember, the channel is for education purposes only, not advisory. If you'd like to talk about your VA claim and potentially obtain representation, please visit veteranling.com to schedule that time. As always, for those who don't know, I am your friendly VA credit attorney, Matthew Lang. Years of experience in the VA. Years of experience representing veterans now, outside the VA. What are we riding on? Something between 17, 18 years? I don't know. Time is getting away from me. We've been doing this for a while. So, we're going to do something similar to what we did last week. I took a topic last week we've talked about before, and we went into it. And why did we go into it again? Well, because it's something that I've seen constantly be an error within the VA system, constantly be trained incorrectly, constantly be misunderstood, and constantly be misapplied by, well, the examiners themselves. And I've watched it get worse every month, every day, every year. And yes, as I have mentioned before in other videos, I do see the bad and the ugly of the VA. So is it true that this error is so bad it happens every time? No. But it's frequent enough to catch my attention, and I wanted to make sure we understood it. So, we're going to do something similar to this week. We're going to pick another topic. Another topic that has risen to, again, the number 1, number 2, maybe in the top 5 of VA errors, and has been continuously going on year after year after year, and from my experience, even from within the VA, and what I see now, it's only getting that much worse. What am I talking about? Well, I'm talking about the cornerstone of a fair VA decision. I'm talking about the reasons and bases requirement. Now, this reasons and bases requirement is a fundamental principle of due process within the VA claim system. It's not merely a formality, but a crucial procedural right guaranteed to every veteran claimant. Now, its purpose is to ensure that the veterans understand VA. Its purpose is to make sure the veterans understand the decision on their claim. The veterans have got to be able to make an informed decision about whether to appeal and how they can effectively participate in the appellate process. So if evidence got missed or something was actually lacking somewhere, or you were persuaded based upon all the evidence that service connection wasn't going to be granted, you've got to explain to the veteran why, so that they're not just sending in stuff that it makes it look like was missing that might still be in the file, and then you're just wasting your time denying a claim because, well, you've already looked at that issue. So it's got to be easy to understand for the veterans. Now, it's also got to be easy to understand for the courts. The courts have to understand what your decision was for too, VA. Because if you don't write a decision that meets the reasons and bases requirements, that is informative and that's clear, and it gets appealed all the way up, and the courts look at it and go, well, you filled the reasons and bases and we can't figure out what your mindset was here and what you actually weighed or assigned value to, then all they're going to do is, after the veteran has waited for a number of years, is send that claim back to you to do it, well, hopefully right the next time. But why make the veteran wait that long? Why do that? So, that's what we're going to talk about today. We're going to talk about this cornerstone of fair VA decision making, this reasons and bases. And I'm going to do my best to stay off my soapbox, because I've come to the realization, probably more so than ever before, that this misunderstanding, I'm going to make the assumption it was a misunderstanding and not what I really feel this may have been based upon experience. This misunderstanding goes as high as the leadership in the VA system. Why do I say that? Because we got a decision from a veteran that was signed by a supervisor, a leader. And I will tell you, on my 17 or 18 years of doing this now, or however it's been, it feels like a lifetime, this is one of the worst decisions I've ever seen in my whole career. It says absolutely nothing, takes in consideration no evidence. It doesn't even come close to meeting the reasons and bases requirement. Heck, it doesn't even tell me what the heck the veteran claimed. So anyhow, let's get that education out there. Let's help all the way up the chain from bottom to top. Let's understand why the reasons and bases requirement exists. And let's understand how to apply it. So what do we do in law, right? We've done this with other videos. What do? Well, we start with the United States Code. We go from our top. We work our way down to the Code of Federal Regulations, and we move our way into the court cases. This helps us to understand the rule, the law, the requirements that are set forth for us in this VA disability realm. So if we start with the United States Code, we're going to find that 38 USC is going to talk about the notice of decisions. And while that statute is going to frame the requirement as a notice, we have to understand that its intent, as interpreted again by the courts, is to provide a meaningful explanation of reasons and bases. Because remember, law can't talk about everything. So we talk about it in the United States Code. We try to explain it some more in the 38 CFR, which we're going to find the 38 CFR is actually going to explicitly use the phrase reasons or bases, and it's going to link it directly to the evidence of record. And when I say link to the evidence of record, it's going to explain to us that we need to be discussing this evidence. But now, it may not be clear enough, so the courts have stepped in. For everybody watching, I want you to understand that this reasons and bases requirement of the decision process is not something that's brand new. It's not something that just came up. It's not something that just recently got passed. Our landmark case comes from 1990, right after the courts were formed. One of the first decisions they made was to talk about the reasons and bases requirement. They gave it teeth and defined its specific components. Because at that moment, they immediately realized they had no clue what the VA was deciding. So, 1990 comes around. Here's what the court was telling us. VA needs to have a written statement of the reasons or bases for the decision. Now you're going to find that's not just any written statement, but a written statement for the reasons and bases for the decision. Also have to have a summary of the material evidence of record, not just a list, but we're going to find a summary being a discussion of that evidence. Because they also found an explanation of why that evidence led to that conclusion. Why did the evidence that was reviewed lead VA to deny or grant? An explanation. We only asked for an explanation. So the courts went on. By the time 1997 came around, well, they had to talk about it again. This reasons and bases was still not being completely hashed out. So the courts determined that they needed to figure out what reasons and bases from an adequate standpoint meant. Well, if they need to be adequate, what must be done? The court identified a couple different things, or a few different things actually. First, you've got to identify the laws and the regulations that were relied upon. You know, sure, the decisions do that. But one thing I've seen is we'll just list a bunch of rules and laws again that weren't relied on or even relevant to the situation. And if they were relied on, well, that's a bummer if they're not relevant. So we'll look deeper into it, but identifying the laws and regulations relied upon. Discuss all issues raised by the claimant. Discuss all potentially applicable provisions of law and regulation. So this means, VA, you can't ignore a theory of entitlement simply because the veteran didn't phrase it perfectly. If the evidence suggests a different basis for service connection, say secondary service connection versus direct, the VA must address it. And yes, this is a problem. I see this not get addressed in decisions all the time. I see stuff like where the courts have said a mental condition is a claim for all mental conditions, because again, the veteran's not required to phrase it perfectly. So why they may think they have one condition and then a different diagnosis shows up in the evidence, you still have to address it and can't ignore it. We've seen that too, where the condition gets ultimately ignored. So reasons and bases is really coming down to not just identifying laws and regulations, but discussing raised issues and potentially applicable provisions of the law and other potential theories and issues that the evidence raises. Now the courts went on. We hit the year 2000 where we hit the Veterans Claims Assistance Act. Well, now the courts reinforced the VA must not only list the evidence, but also analyze it. Yes, VA, that sole list you give does not meet the requirements of a summary. The court said so. You must analyze it. So the decision must account for all evidence that it finds persuasive and unpersuasive. Must provide reasons for rejecting evidence that is favorable to the claimant. And must explain why persuasive evidence outweighs favorable evidence. So you really have to break down this analysis. You can't just click a couple buttons and let some words spew on the piece of paper. The requirement since 1990, if not before, was to explain your decision, to write a full rationale, to discuss the evidence, tell us what evidence was persuasive, what evidence was not persuasive. Why did you reject this evidence? Why did this evidence weigh more? And not just a reason, but a valid reason at that, a legal reason. Because a failure to discuss significant favorable evidence is a clear reasons or bases error. All right, so hopefully that makes sense. It's the basic concept that reasons and bases is requiring a full explanation and not just a bunch of conclusionary text spit out by a computer system. Because in all honesty, I would be worried, and I was, to be just spitting out text that a computer spits out by a click of a button. Especially today, I would be more concerned. Because, well, I think computers can do that on their own, and that would have left me without a job if I was still within the VA system, and that worried me. But that's my own personal experience and opinion. The point here is reasons and bases. Again, weighing of the evidence, probative value assignments, discussion of the evidence. So let's look at some of the practical requirements of a VA decision letter. So when distilled into practical drafting requirements, a complaint VA decision, typically a statement of the case or supplemental statement of the case or appellate purposes or rating decision or BVA decision, whatever it may be at the time frame we were operating in, the rules. Well, they all must include, one, an identification of the issue. It's got to be a clear statement of the claim being decided. Two, a summary of the relevant evidence. A narrative summary of the material evidence considered. This includes the service treatment records, the private medical records, lay statements from veteran, family, or friends, VA examination reports, medical opinions, and so forth. My favorite one has been our fee agreement and our representation form in that list. I never understand how that's relevant to the situation, but maybe we can do better. Now, that's the identification of the issue. That's the summary of the relevant evidence. You've got to have a citation of relevant laws and regulations. So we reference to the specific legal criteria that must be met. For a direct service connection claim, that is often the three elements. And I've said it multiple times. If we break VA down to a simple foundation, we've got current disability, we've got an in-service event, injury or disease, and we've got a medical nexus linking the current and the past. Discuss the evidence in all of those elements. reasons and bases. The application of law to fact, the why. This is the core of the reasons and bases. The decision must explain which elements were met and which were not. Analyze the evidence. The VA examination report dated X is more persuasive than the private opinion dated Y because, and please don't tell me it was because somebody reviewed records and somebody did not, because that's not a requirement. You've got to be detailed. You really have got, you've got to justify. If you're going to call something more persuasive, especially when it comes to a VA medical examination over a private medical opinion, you really have got to explain yourself, especially when we see private medical opinions are much better than our VA counterparts many times and more adequate. You got to resolve conflicts in the evidence. The veteran's lay testimony of constant pain is credible, but without supporting medical evidence, it may not be a competent establishment of, say, a nexus, maybe even a diagnosis, but that's what the decision's got to discuss. Explain the rationale for credibility and probative determinations. It's got to be a clear conclusion, a definite statement of the outcome. Service connection for, say, a low back condition is denied. Now that's the conclusion. Don't forget all that other stuff, because you're good at the conclusion, VA. Don't forget all the other explanation that goes with it. Notice of appellate rights. Again, a clear explanation of the steps and deadlines for appealing the decision. Yes, VA, I don't got any beef on that one. That's usually put into a, so veterans keep in mind, this is actually inside that whole packet letter. It's usually an enclosure. It may not be the best laid out sometimes and easy to find in the paragraphs in the letter, but there's a whole insert that should be in there. So notice of appellate rights as well. Comes with your reasons and bases. So it doesn't just stop with the rater or the RBSR or the DRO. It continues on to that VSR who's also filing that adjudication and prepping that letter. So what are some of the common reasons or bases, deficiencies that led to a reversal on appeal or things that we see back here? Well, boilerplate language. I've talked about it multiple times already. The system, clicking a button in the system, watching it spit out some boilerplate language, some canned text, and leaving it at that. Using generic text that is not tailored to the specific facts of the case, that's an automatic reversal on appeal. You got to explain. Ignoring favorable evidence. We've seen this too. Boy, how frustrating. We will help the veteran provide some of the most detailed evidence, some of the best arguments I'd like to think, and everything that we turn in gets ignored. Kind of like the one that's in front of me right now that I keep kind of looking down at. Everything ignored, all the evidence just ignored. All that favorable evidence, not even considered, not even talked about. Failing to even mention, say, a medical report or a lay statement that supports the claim is, again, failure of reasons and bases in an appeal reversal. Conclusionary statements, it's very similar to the boilerplate. It's making assertions without any explanation. That's what the boilerplate language does. That comes out of the VA system. The evidence is not adequate to grant the claim, or the examiner's opinion is more persuasive without saying why. We see that one a lot. Got to have an explanation. Misstating the evidence. We see this one quite a bit too, actually. Misstating the evidence. Incorrectly summarizing what a piece of evidence says. We will see in decisions that it says that the service treatment records don't contain any complaints, treatment, or diagnoses. And what's the first STR page that we open say? Oh, a complaint or a treatment or a diagnosis of that exact condition. Yeah, so a misstating of the evidence. The narrative has to be accurate with the evidence of file. You have to review the evidence. It's part of the process. It's part of reasons and bases. Another fun thing that we see is the narrative saying that, for example, that there is no diagnosis of the condition, and then the favorable findings saying that the VA examination diagnosed the condition. Kind of a misstating of the evidence. One of those are true, one of those are not, and then we have to go back and see what the evidence says. So VA, just be careful. Be careful. All I'm asking is to follow the reasons and bases, add the explanation. We were used to be taught to put the decision aside for a minute, come back to it and reread it. Make sure it made sense. Read it backwards even. Make sure it makes sense. We've already kind of talked about this one here too, failing to address the theory of entitlement. So for example, denying a direct service connection without considering the potential for a secondary service connection when the evidence suggests it. And we see that again quite a bit as well in our practice back here. So we usually have to go back and tell the VA, look, you missed the secondary. Veteran's not required to claim it that way. It could be that they didn't think about it when they first filed it as a secondary. And then here we are, the evidence is showing a secondary. Maybe when the issue was claimed, the secondary wasn't service connected, so veteran wasn't thinking about the secondary and only claimed as a direct, wholeheartedly feeling like it occurred in service. And then on that same decision is a known secondary condition that gets granted. But then VA, you leave off that plausible secondary now that condition's service connected because the veteran didn't claim it that way. But you're not supposed to. Just some examples. Inadequate analysis of lay evidence. Oh, this is huge. I feel like the veteran is there wanting to be heard, wanting to tell their story, wanting to help you out, VA, and you will ignore their lay evidence. You won't even analyze it. Even the examiners, I feel, do this, which is very discouraging because there's a lot of good information there. There's a lot of things that are in that information that may not have got documented in service treatment records just because of the situation the veteran was in service, for example. So you can't dismiss a veteran's own account of symptoms without a valid reason or failing to explain why it was not found credible. These are all reversible errors based upon the reasons or bases requirements. So let's conclude this. We went for a little while here. I tried to stay off my soapboxes as much as possible. My point is I want to get across this idea of reasons and bases. The decision is more than just some clicks of a button. The reasons and bases requirement is the backbone of a fair and transparent VA adjudication system. It's a legal obligation rooted in statute, defined by regulation, and enforced by the courts. A properly drafted VA decision is not just a denial or a grant. It is a comprehensive document that demonstrates the VA has considered all evidence, applied the correct law, and articulated a logical path to its conclusion. This ensures that the veteran is not left in the dark and that the appellate courts can effectively perform their oversight role. For a veteran and their advocate, identifying a reasons or basis error is often the key to a successful appeal. So VA, I tell you that. Why? Because I find in every decision I have been handed a reasons and basis error that will automatically have the courts and likely the Board of Veterans' Appeals overturn your decision. But I'd like you to fix it first without the veteran waiting for years. So my point is I will appeal this to you every decision. For since it's been around since the 1990s and maybe even earlier, it would be an obvious error to not explain your decision accordingly. So with that, I appreciate everybody for being here. I appreciate you sitting through these, trying to understand what we need to do to be better. So VA, look for the adequacies in the medical opinions, as we talked about last week, in your own decision writing. And veterans, if you get a decision that looks like it's full of just canned conclusionary text or doesn't really analyze anything, well, don't be afraid to reach out to a representative if you need one. Because the last thing we want you to do, at least for me, is to spin your wheels, waste your time, get frustrated with the VA even more because you're submitting something that they're not actually asking for and they're dismissing you. So don't forget, plenty of representation out there. I've given my information. If you want to contact me, that's totally up to you. I'm not here to sell you anything. I'm here for the mission and for you veterans, as so many other representatives are. Whether they be BSOs, be accredited agents, or other accredited attorneys.